Welcome to The Debate. Today, we are examining one of the most profound and rapidly evolving areas of modern jurisprudence, which is the constitutional front lines of transgender identity and the law.
Right, and we're looking specifically at the deep tensions between personal autonomy, traditional biological definitions, and the role of the state in regulating areas like healthcare, education, and public spaces.
Exactly. It is an incredibly complex area, and the central question before us today is this. Does the Constitution's equal protection mandate require the law to recognize self-identified gender as a fundamental component of personal autonomy, or do competing rights and state interests justify legal frameworks based on objective biological definitions? Now, I will be arguing that legal frameworks absolutely must prioritize self-identified gender as a fundamental human right. It's one that is essential for dignity and equal protection under the law.
And I will be taking the opposing position. I'll argue that the law really must rely on objective biological sex to ensure definitional precision, to protect competing rights, specifically women's rights in competitive spaces, and to uphold the state's traditional duty to regulate healthcare and education. Because, the framework of our legal system requires clear, consistent categories to function fairly for everyone.
To begin, I want to clearly lay out the constitutional and moral imperative of my position here. The recognition of self-determined gender is not it's not just a modern social preference. It is fundamentally essential for individual dignity.
Okay.
When the law refuses to recognize a person's deeply held gender identity, it effectively strips them of their basic autonomy. And we actually have a very clear modern precedent guiding us toward this understanding. In 2020, the landmark Supreme Court ruling in Bostock v. Clayton County established that firing an employee for being transgender is fundamentally a form of sex-based discrimination.
Well, it's definitely worth unpacking how the court got there, though, because it is central to this debate.
Exactly. Justice Gorsuch, writing for the majority, used a strictly textualist approach. He argued that it is impossible to discriminate against a person for being transgender without taking that person's biological sex into account. I mean, if you fire a person assigned male at birth for presenting as a woman, but you wouldn't fire a person assigned female at birth for presenting as a woman, you are penalizing them based on sex.
Right.
The court recognized that transgender identity and sex are inextricably linked under the law. This was a massive step forward for equal protection. Yet we are now looking at recent 2025 and 2026 actions by the federal administration in states like Iowa, which explicitly seek to roll back these exact protections. They are restricting gender-neutral designations on passports, on birth certificates, and I view these actions as unconstitutional violations of civil rights. They retreat the promise of equal protection by essentially weaponizing state administrative power against a vulnerable minority class.
I hear that, but the challenge with extending the Bostock logic to every single corner of the law is that Bostock was narrowly focused on Title VII employment law. Who gets hired, who gets fired?
Sure.
It was not a blanket redefinition of sex for all constitutional purposes. The law fundamentally requires definitional clarity, and objective biology provides the stable foundation necessary for administering civil rights in broader society. When we prioritize subjective gender identity over biological sex in the legal code, we inevitably undermine existing sex-based protections that took, frankly, decades to build. We see this tension most clearly when we look at the necessity of preserving fairness in women's sports, bathrooms, and locker rooms.
But doesn't that assume that biological sex is the only valid metric for organizing those spaces?
Well, it assumes it is the most objective metric for the law to rely on. If the legal definition of sex loses its objective biological meaning, the legal foundation for protecting sex-segregated spaces dissolves entirely. I mean, how do you enforce Title IX protections for female athletes if the legal definition of female is entirely decoupled from biology?
Therefore, I view the 2025 and 2026 executive orders issued by the federal administration, which assert that sex is binary and immutable, not as discriminatory attacks, but as valid, necessary administrative efforts. They are designed to maintain consistent, predictable interpretations of federal civil rights across the board. Removing gender identity from federal civil rights interpretations isn't about malice. It is about ensuring the law relies on observable, objective metrics rather than internal, subjective states of being.
When we talk about objective metrics, though, we cannot ignore the very real objective medical realities facing transgender individuals today. The law doesn't exist in a vacuum. It applies to human beings seeking medical care. And this brings us to a major point of contention currently under review by the Supreme Court, which are state bans on medical treatments for minors, specifically puberty blockers and hormones.
Right, which is a perfect example of where the state's interest clashes directly with this concept of absolute personal autonomy.
It is, but look at how the Equal Protection Clause of the 14th Amendment operates here. The 14th Amendment essentially says the government cannot deny any person equal protection of the laws. When a state steps in to categorically ban a specific type of healthcare only for a specific class of people, transgender youth, it is a direct violation of that principle.
But the state...
Let me just finish this thought. The state is essentially saying that cisgender minors can receive certain hormonal treatments for various medical conditions, like precocious puberty. But transgender minors cannot receive those exact same treatments for gender dysphoria. Major medical and psychiatric organizations recognize these treatments as medically necessary for treating gender dysphoria. Banning them is textbook discrimination. It violates the core tenets of equal protection by targeting a marginalized group and denying them care that is freely available to others.
Can I pause you right there, though? You're framing this as a straightforward 14th Amendment violation, but courts have long held that the state has a unique, compelling interest in regulating medicine, particularly for minors who cannot legally consent. The Equal Protection Clause does not strip the state of its duty to protect children.
But protecting children shouldn't mean denying them established medical care.
Opponents of these treatments reasonably view them as experimental or worse, permanently harmful to developing children. We're talking about irreversible developmental changes, bone density impacts, fertility questions. For the listener, when lawyers talk about a compelling interest, they mean a reason so important that the government is justified in restricting certain liberties. Protecting the health and long-term well-being of children is widely considered one of the highest compelling interests a state has.
Even against the advice of their doctors?
When there is substantive, ongoing debate in the international community, look at countries like the UK and Sweden pulling back on these exact treatments, the state has not only a right, but a duty to intervene. The government frequently regulates or bans medical procedures for minors because children lack the capacity to provide true informed consent for life-altering treatments. Treating state intervention as mere animus completely ignores this very real protective necessity.
Okay, if we accept that the state has a compelling interest in child welfare, we must look at the actual outcomes of these bans. The medical consensus in the United States overwhelmingly points to the fact that banning medically necessary care actively harms the mental health and well-being of these minors. The state is not protecting them. It is substituting legislative mandates for individualized medical expertise. But this question of state intervention versus individual autonomy doesn't stop at the doctor's office. It follows these kids right into the classroom. Let's look at the recent push for parental disclosure policies in schools.
Yes, and the educational sphere is where this tension becomes even more pronounced. Recent legal rulings have heavily favored parental rights, and the Supreme Court has indicated that schools may be constitutionally required to disclose a student's gender transition to their parents. The foundational logic here is deeply rooted in constitutional history. Parents, not the state or the local school district, have the primary right and responsibility to direct the upbringing, education, and health care of their children.
Which sounds perfectly reasonable until you look at the real-world application for vulnerable youth.
But the legal baseline has to assume that parents are the primary caregivers. If a child is socially transitioning at school, using a different name or different pronouns, that is a significant psychological and developmental event. For a public school to actively conceal that information from parents fundamentally usurps parental authority. It substitutes the judgment of school administrators, who are agents of the state, for the judgment of the family. The Constitution has traditionally heavily protected the family unit from state interference.
I understand the constitutional weight given to parental rights, but that argument assumes every family dynamic is safe and supportive. By focusing entirely on parental rights, the law is completely sidelining student autonomy and, crucially, student safety. What happens when forced disclosure policies mandate that a school essentially out a transgender student to parents who may be abusive, violent, or deeply hostile to transgender identity?
That is a terrible scenario, absolutely. But family law already has mechanisms for dealing with abuse.
But school counselors shouldn't be forced to act as a catalyst for that abuse. Is it the constitutional duty of a public school to act as an informant, particularly when doing so prioritizes a parent's desire for control at the direct expense of a minor's physical and emotional well-being? We have to ask ourselves whether the Constitution protects the fundamental dignity of the individual student or merely treats them as the property of their parents until the clock strikes midnight on their 18th birthday. Forced disclosure policies strip away a young person's agency in navigating their own identity and safety in one of the few places they might feel secure.
But consider how difficult it is to build a systemic legal framework around the subjective, assumed danger of parents. The law generally presumes that parents act in the best interests of their children. If we create a legal standard where state institutions default to hiding information from parents based on a generalized fear of unacceptance, we undermine the entire structure of family law. You can't build a foundational legal rule entirely out of exceptions. And this tension isn't just a legal abstraction for the courts to puzzle over. It is deeply reflected in how our society is grappling with these issues. Public sentiment is highly divided, and the law ultimately cannot completely ignore societal realities and consensus.
Are you suggesting constitutional rights should be put to a popular vote?
Not at all. But laws are drafted to organize society, and society relies on shared understandings of reality. For instance, public opinion data from recent years shows that 66% of U.S. adults favor requiring athletes to compete on teams that match their sex assigned at birth. That is a substantial supermajority of the public recognizing that biological categorization is necessary in competitive spaces. The law must reflect this societal need for objective boundaries, especially when balancing competing rights. If we ignore objective biology in favor of self-identification across the board, we alienate the vast majority of society that understands why Title IX and other sex-based protections were created in the first place, which is to ensure fairness and opportunity based on physiological realities.
I acknowledge the nuance in public opinion, and I don't deny that competitive sports present a complex physiological balancing act. But if we are looking at public sentiment as a mirror for the law, I have to point out another crucial piece of data. 56% of U.S. adults support anti-discrimination protections in jobs and housing for transgender individuals. There is a clear societal recognition that people deserve to live, work, and exist in public spaces without facing systemic prejudice.
Which Bostock addresses in the employment sector.
It does, but we are seeing state efforts to dismantle even those basic protections. And more importantly, constitutional rights should never be wholly subject to public polling. If fundamental human rights were dictated by majority approval or comfort levels, many of the greatest civil rights advancements in our history would never have occurred. Equal protection principles must remain consistent. We cannot say that someone is protected from discrimination in the workplace under Bostock, but then allow their fundamental identity to be erased in other areas of public life just because it makes some segments of the public uncomfortable. The Constitution exists specifically to protect minorities from the whims of the majority.
I agree that constitutional rights shouldn't be a mere popularity contest, but society organizes itself around objective, definable realities. This brings us directly to the emerging legislative and judicial trends we are seeing right now in 2025 and 2026. You mentioned earlier that you view recent administrative actions as unconstitutional rollbacks. Let's look closely at preemption laws, such as those recently passed in Iowa, which prevent local cities from maintaining their own distinct gender identity protections.
Those laws are specifically designed to strip protections away.
You might frame that as an attack, but from a structural legal perspective, preemption laws are standard mechanisms. For the listener, a preemption law basically means the state government tells local cities, you cannot make your own rules on this. We need one uniform standard across the whole state. If every single city in Iowa has a fundamentally different legal definition of what constitutes sex or discrimination, it creates an unworkable patchwork of compliance for businesses, schools, and state
state agencies. An employer with offices in 3 different counties could face entirely different liability standards for their bathrooms or healthcare plans. The state has a legitimate, purely administrative interest in ensuring that civil rights laws and definitions are uniform within its borders.
We have to look at the practical impact of that uniformity, not just the procedural justification. When a state like Iowa uses preemption explicitly to tear down existing protections that local municipalities have democratically enacted to protect their transgender citizens, it is not merely seeking administrative harmony. It is actively legislating vulnerability. It is removing a shield. And this systemic approach to disenfranchisement is becoming more aggressive in other areas of the law. Look at the new 2025 laws in states like Kansas, which directly impact the ability of transgender individuals to vote if their ID does not match their gender identity.
Voter ID laws are about election integrity, not targeting a specific group.
But look at how they interact with other laws. When you combine state laws that restrict gender-neutral designations or prevent people from updating the sex on their birth certificates with strict voter ID laws requiring exact matches, you are effectively creating a legal trap. The state makes it impossible to update your documents to reflect reality, and then uses those officially outdated documents to deny you access to the ballot box. If your physical presentation doesn't match the M or F that the state forces you to carry on your driver's license, poll workers can turn you away. This is a direct assault on the fundamental democratic rights of a targeted minority, completely veiled as administrative housekeeping.
The Kansas voter ID laws and similar measures are fundamentally about systemic administrative accuracy. The integrity of the electoral process relies entirely on the state's ability to verify that the person casting a ballot is exactly who they claim to be on the voter rolls. If an individual's identification documents show discrepancies in name, sex, or other key identifiers, it inherently flags a verification issue. Suggesting that this is a targeted, malicious effort at disenfranchisement ignores the broader, critical state interest in electoral security. Just as the federal executive orders seek to maintain civil rights consistency by relying on binary, immutable sex, voter ID laws seek to maintain consistency in our democratic institutions. It all comes back to the state's need for objective, verifiable data. When the law abandons objective biology and verifiable documentation in favor of self-identification, it severely compromises the state's ability to maintain order, provide targeted sex-based protections, and ensure fairness in systemic processes.
I hear your focus on administrative cohesion, but let's take a step back and look at what the law is actually meant to achieve. The law is not simply a filing cabinet. It is not just a database of objective metrics. It is the living mechanism by which we guarantee liberty and justice for human beings. If a legal framework demands administrative accuracy at the cost of a citizen's basic human dignity and their right to participate in society, then we have lost the plot of what the Constitution is actually for.
But a justice system without clear definitions cannot guarantee liberty for anyone.
The Bostock ruling showed us that the law is fully capable of recognizing the realities of transgender existence without collapsing. Whether we are discussing a family's access to medically necessary gender-affirming care, a student's right to privacy and physical safety in their high school, or a citizen's fundamental right to cast a vote without being penalized for their gender presentation, the through line must be equal protection. Personal autonomy and equal dignity cannot be sacrificed on the altar of administrative convenience or rigid biological categorizations that simply fail to capture the complexity of human life.
The biological categorizations you are calling rigid are the very foundations upon which women's rights and sex-based protections were built over the last half-century. If we accept that personal autonomy overrides objective biology in the eyes of the law, we lose the language and the legal mechanisms required to protect vulnerable groups in sports, healthcare, and private spaces. The state's role in regulating these areas isn't about denying anyone's dignity. It is about the incredibly difficult task of balancing competing rights in a pluralistic society. As we look at the Supreme Court's current docket regarding medical treatments for minors and the ongoing clashes over parental rights and student transitions, it is clear that the law must carefully weigh the desires of the individual against the profound duties of the state and the fundamental rights of parents.
As we synthesize our positions today, I believe it is abundantly clear that we are witnessing one of the most profound and complex constitutional tests of the 14th Amendment in modern jurisprudence. From my perspective, the core of the issue remains the primacy of self-identification and personal liberty. The Constitution's guarantee of equal protection must serve as a bulwark against state overreach. Whether that overreach takes the form of banning widely accepted health care, forcibly outing vulnerable students, or suppressing the vote through inflexible ID laws, a just legal system must recognize and protect transgender individuals for who they are.
And while we fundamentally disagree on the framework, I think we have found a strong point of convergence today. We both recognize the immense gravity of this constitutional moment. My position remains that objective, biological definitions are absolutely necessary to balance competing societal needs, to protect established sex-based rights like those in Title IX, and to maintain the integrity of state administration and parental authority. The tension between personal autonomy and state regulation in this arena is not just a passing legal debate, it will undoubtedly shape constitutional law for decades to come.
It absolutely will. Examining both sides of this deeply divided issue is essential if we want to truly understand the legal mechanics and human stakes at play. There's so much more to explore within constitutional law regarding how these intersecting rights are interpreted and how the courts will ultimately navigate the boundaries of equal protection and state interests.
Indeed. The questions of dignity, biology, and the law are far from settled, and they require exactly this kind of rigorous, respectful scrutiny.
Thank you for joining us for this examination of the constitutional front lines of transgender identity and the law. We leave you, a listener, to weigh the evidence and constitutional arguments presented today, and to form your own conclusions on this vital subject.